Hello, and welcome back to Funeral Industry Insights. This is a podcast where we talk about one of life's toughest subjects and the different aspects of the funeral industry. I'm your host, Michelle Dwyer, and in today's episode, we're looking at what happens after the funeral, particularly in New South Wales. When someone passes away, the funeral can often feel like that's the final chapter. But legally and practically, there are still a number of important steps that need to be taken. So these steps can feel quite overwhelming for families, especially in the midst of obviously grief. So today we're going to walk through the process from reading of the will to notifying the right authorities and eventually to distributing the estate. So the funeral's taken place, family and friends have gathered, and your immediate goodbyes have been said. So what's next? So the first thing is usually to check if your loved one has had a legal will. So quite often this is also known beforehand because throughout that process of organising a funeral, it is generally a question that is asked of the funeral director, just to ensure that your loved one's wishes about their funeral are known as well. So this will is a legal document. It sets out how a person wants their assets to be distributed. So who they've chosen as their executor, also that person's responsibility for carrying out the wishes as well. So if there is a will, the executor steps into that role. So if there isn't, then the estate's handled under what's called the rules of intestacy, which we'll come back to later. So most wills are kept with a solicitor. Some are kept in a safety deposit box. Some people just keep them at home as well with their other important documents. But once it's been located, the executor is responsible for arranging to read it out. Okay, so unlike the movies, it really isn't as dramatic as what they make it, be around a lawyer's desk and things like that. So in reality, the executor simply provides copies of the will to those who need to see it, which is generally solicitors or those that are beneficiaries in that will itself as well. So the will names these beneficiaries, and these can be people or organisations who are going to inherit, and it's usually outlined in the estate as how it's going to be divided. Okay, so at this point, there are some practical jobs that need to be done. So some authorities and organisations that need to be formally notified of your loved one's passing. So this can include Services Australia, so Centrelink, DVA, especially if your loved one was receiving pension or benefits, Medicare, private health funds, the ATO, banks, financial institutions, superannuation funds, insurance companies, your utility providers such as your electricity, water, phone, and if relevant, government agencies such as RMS, like driver's license, cars, things like that. So many of these organisations will ask for a copy of the death certificate before they'll close accounts or release funds or anything like that. So this should have been organised through your funeral director, and usually this document arrives within about 3 weeks after the funeral service has taken place. So let's now talk probate. So probate is the legal process where the Supreme Court of New South Wales confirms that a will is valid, okay, and then it gives the executor the official authority to manage the estate. It's often required before banks or institutions will release funds or property, or before the property can be sold or transferred and things like that too. So to apply for probate, an executor needs to advertise their intention to apply. Okay, so this is done online through the Supreme Court Registry. So you complete the court forms, lodge the original will, the death certificate, and an inventory of your loved one's assets and liabilities. So if probate is then granted, the executor can then move forward with collecting and distributing the estate. But what if there's no will, right? So in this case, a family member, usually the closest next of kin, can apply for what's called letters of administration. So it gives them similar powers to an executor, but the distribution will follow the intestacy law rules set out in New South Wales law. Okay, so once probate or administration is granted, the executor has several responsibilities. So you need to obviously gather the assets. So this can mean closing bank accounts, selling or transferring property, dealing with investments, collecting insurance payouts. Then what you'll need to do is pay off any debts or liabilities. So that would be the mortgages, loans, taxes, outstanding bills. Then what happens is you prepare a statement of distribution. So this is what shows what's left basically in the estate after all those debts have been settled. So only after those steps are completed can the executor begin distributing inheritances to beneficiaries. So during distributing an estate, look, it can be straightforward if the will's clear and the assets are simple. For example, if there's just money in the account and a car, that's simple. But it can also be really complex if there are multiple properties or there's businesses or even just disputes between family members. So the executor is legally required to follow the directions that are in the will. Okay, and if no will exists, then the Succession Act of 2006 sets out exactly who inherits and in what order. Okay, so here's a quick outline of how intestacy works in New South Wales, okay, because it can be a little bit confusing, but it's generally a spouse or a de facto who's usually first in line. Okay, if there are no children from other relationships, then if there are children from other relationships, then the estate's usually divided between those children and the spouse. Okay, now if no spouse or children, it goes to the parents. Okay, then siblings, then grandparents, aunts, uncles, and so on. Okay, if there's absolutely no relatives at all that can be found, then the estate passes to the state of New South Wales. So this is why it's really important to make sure that everyone has a legal will, no matter your age. If you've got anything that you feel is worth passing on to somebody else and you've got wishes that you would like that to happen, then you need a legal will. Of course, not every estate runs smoothly. Sometimes wills are challenged. Maybe a family member feels that they've been unfairly left out, okay, or they believe that their loved one wasn't of sound mind when the will was made. So in New South Wales, eligible people, which is normally like a spouse, children, or dependents, etc., they can make what's called a family provision claim. Okay, so disputes are handled through the Supreme Court as well, but they can also delay the distribution until the matters are resolved. Okay, so executors must be careful to manage these processes fairly and legally. Okay, so, but once everything's settled, assets have gathered, debts have been paid, distributions have been made, the executor prepares what's known as a final account. Okay, so this account's usually shared with the beneficiaries as well, and it just shows them so they can see exactly what was received and what's been paid out. And at that point, the executor's role is now complete, and the estate's considered final or finalised. Okay, so for families, it's important to know that executors don't have to navigate this process on their own. Solicitors, accountants, even financial advisors can assist them with probate applications, but tax matters, and also with the asset transfers as well. There are also government resources available, such as the New South Wales Trustee and Guardian. They can step in if no one is willing to, or if no one's willing to act as an executor as well. So while the funeral service may feel like it's the end, there's often a really long journey still to go in managing someone's affairs. Even just from locating the will, notifying authorities, applying for probate, paying the debts, distributing the estate. This process can take many months, and in some complex cases, even years. I know at the moment we've been advised that the process for probate is at least 6 months. So yeah, there is definitely a time there. But at its heart, it's about honouring a person's wishes, supporting their loved ones, and just ensuring that everything is handled fairly under the law. Okay, that's the main thing. Um, yeah, so look, that brings us to the end of today's episode. I hope this breakdown helps you understand what happens next after the funeral service. And maybe it's a little less daunting now that you sort of have it explained in a little bit more detail. So, look, thank you so much for joining me. As previously, please remember to subscribe wherever you listen to your podcast. And until next time, take care and look after each other.